Okay. Good afternoon, everyone. Thank you for being here with us today. We are pleased to have a guest speaker attend our HONSAC meeting for March 7, 2013. Today we have the Hawaii Immigrant Justice Center at the Legal Aid Society of Hawaii giving us a presentation on language access in healthcare, its rules and reimbursement for immigrant services. The Immigrant Justice Center provides legal services and does community outreach and community education for indigent immigrants. The center provides legal services for domestic violence and sexual assault, human trafficking, family reunification, child protection advocacy, citizenship, removal defense, and crime victims. The center also builds bridges between immigrants, community service providers, and policymakers by training and educating community groups, social services agencies, and government agencies on topics that are key to helping the immigrant community. Today we have two speakers. Please join me in welcoming Jennifer Jung and Bowman Chin. Thank you.
Okay. Well, as mentioned, I'm Jennifer Jung. I'm the newest staff attorney with the Hawaii Immigrant Justice Center. So today I've asked Bowman to please feel free to cut me off or cut in whenever I make a mistake or if he needs to expound on something. We also extend that to you as well to please ask questions as we continue in the presentation if anything's unclear or if you would just like to know more about it. On the front end, we do want to clarify that this is a general presentation of language access. So if you have specific questions, then we can go back and research the issue if we don't know right now. And also for potential outreach presentations to clinics, we can tailor the presentation as need. Okay, so language access and healthcare. What is the law? Under Title VI of the Civil Rights Act of 1964, it provides that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation. Also want to highlight that under the Affordable Care Act, Section 1557 extends the application of Title VI of the Civil Rights Act to health programs or activities that are federally funded. Continuing on, the law for national origin discrimination, that includes discrimination that is on the basis of limited English proficiency. And the case law for that is Lau v. Nichols. Just a minor correction there, it should be 414 U.S. 563 instead of 536. And under that case, non-English speaking students brought class action suit against officials of the San Francisco School District for failure to establish programs to rectify students' language problem. So just the importance of paying attention to the individuals in our community who are limited English and are wanting to take advantage and participate in the agencies that are covered under federal funding. So continuing on with what is the law, the federal agencies funding services under Executive Order 1316-6, which President Clinton signed in 2000, this extends the Civil Rights Act, Title VI, to federal agencies and directs all federal agencies to work to ensure that programs receive federal financial assistance are providing meaningful access to limited English persons. And we'll go into more depth about what meaningful access means and also what limited English proficient also means. Okay, so if the recipient of federal funds is found to be in violation of the language access laws, federal funding agency can terminate funds. And so today we want to clarify a little bit more about how you can avoid termination of federal funds, as we know that's very important. If somebody sees that an LEP individual is being discriminated against, they can file a complaint with the Office of Civil Rights of that particular federal funding agency. Okay, and then in many situations, the agency will then work out a resolution agreement with the recipient. The handout that I provided a little bit earlier before I started just highlights two recent civil rights resolution agreements with hospitals and healthcare systems. One is found in, I believe it's Woodstock, Virginia, and the other one was located in Colorado. And on the first page, the one highlighting Virginia, just wanted to highlight some of the language in the third paragraph that highlights meaningful access to quality health care for LEP individuals. It mentions, if providers and patients do not understand each other clearly and cannot communicate effectively, then the quality of the care is compromised and sometimes even jeopardized. So just, again, highlights the importance of having language access for our LEP individuals. And in the Colorado Memorial Health System on the back of the page, we see that a complaint was originally brought against the health system related to an ADA complaint. But then in the investigation process, OCR uncovered additional issues related to language access and expanded the investigation to encompass these issues. So again, highlighting the importance of providing adequate language access to LEP individuals. Okay, so bear with me. I know our presentation has to be kind of brief today, so I may hurry through some of the slides. Important to know that there is state law that also requires language access. Excuse me. And it established the Office of Language Access, which I know you're familiar with. And I also know that you guys did receive a presentation in December, I believe, on the vital documents. So that portion of it, I'm not going to go into as much depth. Okay. In contrast to the federal law, the state law will not terminate any funds if there's found to be a violation. And then again, on the state level, a complaint can be filed with the Office of Language Access. There is no federal or state private cause of action for violations of language access. And going into national origin discrimination, this means that no one can be denied services because of their birthplace, ancestry, culture, or linguistic characteristics common to a specific ethnic group. We see for limited English proficiency that this means individuals who, on account of their national origin, do not speak English as their primary language, or they identify themselves as having a limited ability to read, write, speak, or understand the English language. An LEP individual is not the same as non-English speaking or reading. For example, when we're identifying in our office a client who might be considered an LEP individual, they may be able to converse with us on the basic level. They may be able to answer, what is your name? What is your birth date? Basic questions like that. But then as we go into more complex details of describing the complexities of our law, especially immigration law, what remedies they may have available, that's when the communication might not be as clear, the understanding might not be there. And we have to be very sensitive to providing for an interpreter when it's needed. And oftentimes the client might shake their head, yes, I do understand what you're saying. They might even say, yes, I understand. But in reality, if you try and dig a little deeper, you realize that they're not understanding the message of what's being communicated to them because of the complexity of the message. So it's important to note, just if somebody does speak some English, that doesn't necessarily preclude them from being an LEP individual. Okay, so who must comply with limited English proficient federal and state laws? This includes all programs and operations of entities that receive federal or state funds or assistance. So after we've identified the LEP individual, what do you need to provide for that person? And meaningful access is the standard. And that means to be informed of, participate in, and benefit from the services, the program, the activities offered by the entity receiving federal or state funding. And this also means interpreter services at no cost to that individual. This may include multilingual informational brochures, posters or handouts describing services, programs, and activities, and other key documents that are necessary for the delivery of services. It's also important to note that service delayed might be considered service denied. especially in the emergency healthcare sense. The more emergent the healthcare need is, the more probable that statement is probably to be. Okay, so language access law requires recipients of federal and state funding to take reasonable steps to ensure that meaningful access is being provided to limited English proficient members of our society. This is an example of what may or may not be considered meaningful access. If we have Jorge who speaks only Spanish, and if he requests services from you or your office and is told that he will have to pay for an interpreter, would this be considered meaningful access to services? That's a pretty clear example of no. Okay. And then our next slide, May speaks Mandarin. Through a relative, she requests services from you or your office, and then she is told after that to bring the relative to interpret for her. Is she getting meaningful access to your services? No, that's correct. And then the next example, we have Kim who speaks Korean, no English. She requests services from your office. You contact an interpreter, but realize an interpreter can't come immediately. They can only come a week from now. Is Kim getting meaningful access to your services? No. So the answer is kind of more, it depends. Depends on what service she's seeking. If she's going into an emergency healthcare situation that she needs immediate health attention, then the answer is probably no, she's not getting meaningful access. If it's a doctor's appointment that can be scheduled further out without a negative consequence to her health, then the answer is more likely it's probably abiding by meaningful access. Okay, so in order to assure language access, the following things can be adhered to. Conduct the 4-factor analysis, which we'll talk in a couple of slides about. Develop a language access plan and also implement that plan, as well as provide appropriate language assistance. So, while it's designed to be a flexible and fact-dependent standard, the starting point is always at an individualized assessment. For the federal law, every entity receiving federal funding or assistance should have a written language access plan and an individual assessment. On the state level, every state or agency or department and nonprofit receiving state funding must have a written language access plan or individual assessment. And the example we like to use for that too, and determining who actually qualifies and must be held to the standard of providing meaningful access. For example, at legal aid, there are multiple units within legal aid. There's our unit, which is Hawaii Immigrant Justice Center, which is the immigration unit. We also have the family law unit. We also have the consumer unit, and we have more in addition to that as well. If our office, Hawaii Immigrant Justice Center, receives federal funds, does that mean that the rest of legal aid needs to comply with Title VI requirements? Yeah, so it doesn't just isolate the unit that is receiving the federal funds, it affects the whole organization. So the 4 key factors for evaluating your language access plan, you need to balance the following: the number or proportion of the limited English proficient persons who are eligible to be served or encountered with your programs. Number 2, the frequency with which that LEP person might come into contact with the program. And then number 3, nature and importance of the program to people's lives. And number 4, the resources available to the grantee and the cost. I want to emphasize number 3 and number 4 in the healthcare setting, because number 3, the nature and importance. Given the nature and importance of healthcare services, providers do have special obligation to ensure patients have language access. And I do recommend, if you have a chance, to read the cited article there. Number 4, resources available to the grantee. Large organizations such as hospitals, health plans, and health systems should universally be providing language assistance services. Some of the questions that you can ask in creating a plan: have you determined the impact on actual and potential beneficiaries if delay and the language access is occurring? And if you've identified what those delays are, how can you move forward from there and then help those delays to minimize? Some questions that need to be asked are: have you identified the resources needed to provide meaningful access for LEP persons? And are those resources currently in place and being utilized? Now, I know you guys had vital document training already, so I'm going to kind of go quickly over this. But a vital document is any document that is critical for ensuring meaningful access to the recipient's major activities and programs by beneficiaries generally and LEP persons specifically. At what point does a document need to be translated? Whether or not a document is vital might actually depend upon the importance of the program and the consequences of that LEP person not being able to fully utilize the program in a timely manner. Some important examples of vital documents that might not necessarily apply to the healthcare but are on that same level: eviction notices, termination of benefits notices. Also, when we look at the healthcare examples, important discharge documents, consent and complaint forms, notices advising LEPs of free language assistance, and also intake forms that might have potential for important consequences if they're not filled out correctly. Now, the safe harbor rule is a way of that ensuring compliance with Title VI. If written translations are provided in these circumstances, then that is strong evidence that there is compliance. Failure to abide does not necessarily automatically mean non-compliance, but it does depend on balancing those four factors that we discussed earlier. If, however, it's absolutely unreasonable to provide the language access, then at a minimum, there needs to be provided oral translation of the vital document to the LEP individual. So here, going to a little more depth about what the safe harbor is. If you have a group that's 1,000 or more in your eligible population or among your current beneficiaries, then translation of vital documents should be followed. In addition to that, if you have more than 5% of the eligible population and there's more than 50 in number, also adhere to the translation of the vital documents. If there's 5% or less of the eligible population is considered LEP, and that number is also less than 1,000, then there's no translation required. And again, that's not necessarily guaranteeing that there's not a violation of Title VI, but it is very strong evidence that there's no violation. And is there a safe harbor for oral interpretation? No. Whenever somebody requests an oral interpretation, that needs to be followed as quickly and as possible as it can be. Okay, go over this. When you're assisting LEP persons, some things that the hospitals and different offices might consider. What would they do if an LEP individual wanted services from the office and they called your office? How would they be directed to call back with an interpreter or to call back so that the hospital could get an interpreter? And then also, what if that person walked into the office? Is there a system in place that can allow for quick interpretation, whether it's through using a bilingual access line like our office does or other telephonic interpreters? Okay. And with that, you guys have some resources on the slides that have a wealth of information, especially concerning the National Health Law Program. It really has a lot of good documents that explain in further detail about what language access requirements are for healthcare systems. And then Bowman's going to get into more details about reimbursement for immigrant services.
Any questions? Any questions?
I got about 1,000.
Yeah.
But you can use family members as a translator. I mean, they're involved in your care, and sometimes who knows English better, but family can then do that.
If there's a special, specific request by the LEP individual to use the family member, then that might be appropriate for the case. However, in situations that we've run into, and also could be in the healthcare system too, we don't know if that family member might have an interest that is adverse to the individual who's seeking services.
But you don't even know that with an individual that speaks English, whether or not there's any adverse.
So that's where it's important to get an unbiased interpreter to actually get consent from the individual to use the family member. So even in our office, that's what we try to do. Even if the LEP individual is requesting, if they say initially like, oh, I want to use this family member, I want to use my mom or my auntie, or hopefully not a minor child. But if they say that, then we try and follow up with a teleinterpreter to actually get consent from the person outside of the presence the family member that they want to have interpret for them.
And a lot of times we use, the telephone and speakerphones with staff, when we call into them so that they can interpret if we don't have anybody that's really physically there.
Available.
And I think the thing is to get somebody who can understand and interpret what the person said.
Right. That's good though.
I think, the part about DOA is when you are in healthcare and you're doing hands-on stuff, and you can't wait even an hour because you're right in there taking care of the patient, and the easiest access to healthcare is the family. And many times it's included, especially in long-term care. You would include it in their plan of care, where certain things come up, contact this person, the daughter, or the son, or the sister, or cousin, to do that interpretation. And because it's over a period of time, because if you had to use an outside person, that would be a tremendous amount of financial resources for your daily business.
Well, I think the important thing there too is, like we emphasized, if there is going to be a family member who's utilized for interpretation services, then there definitely needs to be a consent and a fully meaningful consent where the person has an opportunity to request somebody else if they don't feel comfortable having their family member be the person to interpret. And that's where you do have to do the 4-factor analysis and balancing what are the resources that are required and how great is the need. So there's not necessarily one straight answer that we can give depending on the situation, but if you balance all those factors. And I think as Kleben, is that his name? The guy that did the information on the vital documents. Cleaver, yeah. So I think he had touched on the importance of identifying the LEP individual early on, and then if you can get a consent from that person in your file to speak with a family member, that might be a way of dealing with the language issue. But also at the same time, there is a responsibility on the part of the healthcare provider to provide interpretation services where needed and necessary.
Well, that's when the expense comes in. And, there's no reimbursement for the facilities. So I'm dying to hear what you have to say about reimbursement.
Okay, yeah, I know. We knew that would be the kind of the crux of today's presentation for you guys, would be the reimbursement.
What's actually the definition of this?
Sorry,
of an immigrant.
Of an
Is it
immigrant.
born somewhere else, is it a legal status, or something like that? People who show employment?
I guess a question for that: in what situation or circumstance are you talking about when you say immigrant? So,
Documentation or
regardless of
you
status. Regardless of status, if the person doesn't speak English, then they do need to have.
So it's really just a language thing, not necessarily a.
There's no immigration analysis that needs to be.
So it's really just language.
Right. Yeah, you don't need
They
to.
could be born in the United States and not speak English. That's what I think,
Right. Yeah, so regardless of immigration status, if the person is limited English proficient, then there does need to have that language access consideration made available to them without requesting like a passport or anything to verify that.
Going back to the question there, I think should point out that at least you plan for it, and it was good when you plan for potential language access issues. So possibly if you did see an issue during the planning process, maybe you need to incorporate the 4 factors during that time and not subsequently. But it's good that you did plan for it. Other questions? You were saving all for me, right?
She has 997 more.
We'll do the best they can.
Right, and that's where, I know we mentioned before we even started the presentation that the questions might be very in-depth and detailed and maybe not satisfied fully by this presentation, but we welcome any questions for us to take back and possibly look into whether we can bring a more satisfactory answer later.
No, but I didn't know about the 4 criteria.
Right, and also availing yourselves to the safe harbor. Also, if you don't have 1,000 members of a particular population that need a certain language, then you might be okay
Well,
for translation.
Yeah, in long-term care, you're taking the whole allowable, because you never know where they're coming from, you know, so there is going to be that, if it's already, it's there, you have 1,000 people that probably, you know, maybe not, or really LED, so.
Mm-hmm. Definitely.
Before we finish, I think you brought up a very good point. You can never really anticipate every single situation. I think an interesting thing happened. I was actually, some of my clients are actually part of the trafficking cases you heard about, the Thai farm workers. And when they're doing an investigation, and none of the parties seem to know until afterwards, the same interpreter was used for the defense, the prosecution, and the court, which could solve his problems, right? So, and nobody knew till the trial. So sometimes you can be say like, oh, we're doing the best we can, but you don't know till later that maybe it's what you've done not sufficient.
That's true, and even for human trafficking victims that might be going to emergency services, the emergency room or whatnot, if especially if they're a sex trafficking victim and the pimp is accompanying them or something, you might just want to be extra cautious with who's allowed to be doing the interpretation for them and speaking on behalf of that victim.
Any other questions?
And you guys can definitely ask language access questions during the reimbursement portion too. Do you want me to do the quick read?
Hi, before I begin, I want to just go over some things. Our office, like Jen said, with the immigration arm of legal aid, our main focus is on immigrant victims. And I think in that context, we're going to probably talk about immigration victims in the context of getting reimbursement for their services served by the medical providers. Even though we do most of the work is with immigrant victims, we also do work, normal immigration work like naturalizations, getting replacement green cards, that type of thing, the normal course of things. But because our grants dictate what we do most of the time, most of the work is in the immigrant victim field. My thought was that who would you normally see as a medical provider that would overlap with some of our clients? Probably our trafficking victims, which could be sex trafficking or labor trafficking, or our victims of other crimes, which could be violent crimes, but more generally, probably domestic violence victims. Okay. Before I get into the PowerPoint, this PowerPoint was made just for you guys. This is the first time we're doing this, so if there's a little kink, please excuse us, okay? Okay. Because normally we don't do this for somebody like you, because most of our clients are essentially out of below poverty guidelines. They have to be to qualify for legal aid services. So essentially, we're trying to give you some of our experiences we had with dealing with our clients and the medical providers at the same time. Okay. So now, the question is, well, you have an immigrant victim come in, we treat them, how do you get some of your expenses or costs back? We thought of at least 5 ways in our experience that you could try to do so. 1, apply for a claim with the Crime Victim Compensation Commission. Anybody ever done that? Okay, we'll go into more detail later. You can also get some compensation through if they're pre-certified victims of human trafficking. Essentially, if they're identified by a provider that they're possibly trafficking victims, they possibly can be covered for their medical expenses by one of the agencies who generally has a federal grant to do so. And there are a couple in Hawaii at this time. Okay? Other victims could be VAWA, people who have under the Violence Against Women Act. These are victims of domestic violence who are married to green card holders, United States citizens, or trafficking victims who are what we call T visas, persons who've been granted the T trafficking visa status or been certified by the United States Department of Health and Human Services as a trafficking victim. Once they're certified either as VAWA or as a T visa, essentially they can apply for public benefits, which include MedQuest. Also, if we're a medical service provider who was performing a function that was referred to by someone who had was a contractor under a federal grant, they could get compensated for their services also. And lastly, generally, we've always encouraged our clients to pay their medical bills. And one, because it's easier to get their medical records from the provider, because every time they ask the provider for their medical records, which they'll need to document their injuries, they will always be confronted, well, did you pay the bill? So try to pay the bill, at least make partial payments on the bill. Also, our clients generally need to document their presence here in the United States. Paying their medical bills, getting medical treatment documents that aspect. So essentially, we encourage you to do so. Next. CVCC, Crime Victim Compensation Fund, it's under Hawaii Revised Statutes. It covers all necessary medical expenses that the victim may incur. The injury must have a reasonable nexus to the crime. So essentially, if you got a concussion, then essentially treatment for the concussion should be covered under it. The victim must make a police report. So obviously, if there's an LADP issue, meaning interpreter for that, the police should be called in. The CVCC requires a police report as part of its investigation to see if it's a valid claim or not. So it'd be good for everyone involved to do so. The problem is sometimes that some of the victims are very hesitant to make the report because they're afraid they might be turned over to immigration or what we call ICE, and they might be arrested and deported. So there's an issue there about do they want to make the report even though it's to their benefit. Upon substantiation by the CVCC that it's a valid claim, they would contact the provider directly to try to make payment. The source of the funds from the CVCC funds are fines that are issued by the court or levied by the court. So it's not an endless pot, which is why they generally try to call and try to negotiate an amount less than generally what the full amount is. But it's something that they would do to try to save the money for the fund. So be aware that may happen. They do contact one of you. And again, we encourage our clients to make at least nominal payments on the bill they're getting, because we don't want an action to be filed against them and then get a judgment and then have it turn over to collections, which is more stress on a client, something they won't need for their that would not be preferable for them in their immigration matters later. Okay? Because when they do background checks, sometimes the judgment will come up on the background check. Okay? And sometimes these have to be done when we do the immigration filings for their which is their victim visa or their trafficking visa. Also, well, even though we represent immigrant victims, the CVC compensation doesn't just cover immigrants. Immigration status doesn't matter, so it could be a citizen involved. Okay. Questions so far? Okay. List of allowable, non-allowable expenses. Healthcare exams, treatment for sexually transmitted infections, family planning, counseling services, full reach of legal permissible gynecological and obstetric care, prescriptions, medical assistive services, and then necessary mental health care services also. Generally, what's not allowed is the elective type of stuff or general type of stuff. We need something that's focused on the treatment of the victim for the injuries that they received. Okay? Any questions on the CVCC compensation? So something you can apply for anytime there's a crime victim involved, make a report, and then essentially it's not very fast, but at least you may get, if not, there's possibly a total compensation, at least partial reimbursement for the costs. VAWA and T, non-immigrants, this is something they get for either as DV victims or trafficking victims. Once they're approved again, they can take the letter that they get from US DHSS or the approval notice and apply for welfare and MedQuest. So we could possibly have a insurance, medical insurance to cover future medical expenses, and to probably be able to work to try to reimburse you for past medical expenses, which will encourage them to do. Questions?
Income check here or something?
Excuse me?
Is it income check or something? I mean, you say, how do you determine who's eligible to get the services?
For our office?
Yeah.
When they come in, we generally ask them, we do an income check, like, are you working at this time? Even though they're not supposed to work, some of them, they are undocumented, they do work sometimes without immigration permission. So if they make a lot of money, then they disqualify themselves even though they're not supposed to be working. Obviously, they'll have to qualify under our income guidelines. Good question.
But under the Immigration Service, they don't check income for VAWA or T
Right.
applicants.
Yep.
So they might not be eligible for our services, but under immigration laws, they might be eligible to receive a VAWA or T.
One thing also, like once a lot of them, they would want to work, but they just can't because they believe it's unlawful. The prohibition against work under the immigration laws, it's civil, not criminal. Questions? This is something that we've experienced. We've been a grantee under some federal grants, and we usually had a partner, a medical partner, which has been Pacific Survivor Center, and through them, we have gotten our clients served. However, on certain occasions, we have to go to a specialist like a surgeon or maybe like a dentist, and in that sense, the medical provider under PSC couldn't do that job. So she subcontracted that work to another medical service. And they did the work, and then essentially she billed the work that they did to us, and we paid them off. And there's another grant that's been approved but not activated yet. That's pending. They're probably going to affect sometime next year if we're lucky. So essentially, this is pre-existing, and it's going to come back again. So subcontracting from one federal grantee. Okay. But the main thing about this one is that essentially it has to be referred by the sub-grantee that's our partner. It's not about, if they have a treating physician that's been treating this person before, it's been referred to the to the grantee. Obviously, make contact and the grantee has no problem with the provider continuing treatment. That would be fine. Okay? And from what I understand, there is no limit to who the medical provider could be that's going to be reimbursed for their expenses. It could be anyone. Again, we encourage self-pay. We don't want them we don't want a judgment against them later on their whatever they have to do. It causes problems for them because it sometimes shows up on their background checks. It may affect naturalization, so we encourage them to take care of their bills. We try to settle them. Again, we need to, for almost all the cases that we're applying for, when they try to apply for their green cards, they need to document they were here lawfully, and when you're lawfully, you pay rent, you pay medical bills. Other questions you had? This is our address and contact information. Please feel free to call us. There's got to be some questions, right?
Is there, like an agency that, that is an interpreter or have a pool of interpreters that facilities can access?
I think from our experience, I don't believe so. We've been kind of fortunate. We have a contract with the prosecutor's office where any victims of crimes will be allowed to have free interpretation service under bilingual access line. I don't know if something that the medical community could look at, maybe try to do also. And in addition to that, we have a interpreter service telephonically that we use outside of that we use to talk to clients over the phone. And that would pay out of pocket for that also. So maybe what you think, I see no problem with that, but I think there's no one agency that would cover it. Ours is, even though it covers a lot of things, it's not totally comprehensive.
Well, it's kind of like put the facility in a bind.
Yes.
The acute hospitals and long-term care and even some of your care homes. That if you don't have at least some sort of access, how can you stay within compliance with the federal and state law?
Right. I think like my view, like probably the scariest circumstance would be like emergency room treatment, right? So my only thought was that if the person was at least conscious, you could speak to him. At least there's some sort of telephonic capability where you could actually have a telephonic interpreter try to interpret for you. Getting a real live body there is very difficult a lot of times. That's my thought, probably the most viable solution, but I don't know if it's really workable under how you operate your services. Yes?
You just apply for, like, let's say, dental clinics that somebody calls in and they got in an accident, they need emergency surgery on their teeth right away.
I think if they're getting any type of federal or state funds, they would have to follow those guidelines also.
But what if they are okay?
Yeah. It's the agency, not so much the person.
Right.
Yeah, the person could be any of any status. Other questions? This is something like, we just tried to say what our experience, what I thought could be potential avenues of trying to recoup some of the expenses. There may be others, but this is what we've seen doing the way, with respect to our practice. Anything else? Okay.
No, this is just.
Thank you for your time.